In Las Vegas, stories move fast, and so do contracts. Across the country, journalists and lawyers work overtime to keep the public informed and protected. These are their trusted people. When bees disappear, ecosystems go quiet. Food systems feel it. Roughly 1 in 3 bites of what we eat depends on pollinators, and bee-pollinated crops account for about 1/3 of global dietary supply. When reporters disappear, communities go quiet. In the US, more than half of counties now have one or no local news source. Around 50 million people have limited or have no access to local news. In the last year alone, over 130 newspapers shut down. Roughly 15,000 news and media jobs were eliminated in 2024, and about 14,000 media job cuts announced year-to-date 2025, as major outlets continue to trim. Beats go uncovered, promises go unchecked, and creatives get stung by clauses they never saw coming.
You mentioned breaking contracts. It's not always breaking contracts. Contracts are a piece of paper that people sign.
Tonight, we translate legalese into plain English.
Many statutes and laws are enforceable regardless of what you sign.
NDAs, non-competes, work for hire, ownership of your name, and those sticky clauses that buzz right past you until they don't.
And a legal dispute involves a certain amount of time, stress, money.
We'll tee up a deeper dive soon. This is Be Advised, Clause and Order. Stay with us. Every bee serves the hive, not itself. Every role, no matter how small, sustains the whole. Here, former and present journalists gather like bees, drawn to what's raw, real, and sweet. Each story is a drop of nectar, gathered from the wild fields of experience, spun into something golden. From the sting of truth to the sweetness of healing, this is where we build the hive. Bees don't question their purpose, they simply build. They gather light from the broken things, turn it to sweetness, and leave the world better than they found it. We do the same. One story, one truth, one drop of honey at a time. This is the Honey Pot, where words heal, hearts rebuild, and purpose buzzes loud. The Honey Pot is brought to you by Medrala Law Firm, your legal team for life's unexpected stings, and by TrueCore Wellness, helping you heal from the inside out. Together, they keep our hive strong. Hey, honeys. Thanks for joining us on the Honey Pod. I'm Paulina, and today we are joined with our sponsor, Medrala Law Firm, Jakub Medrala. Now, Jakub, we met at the Polish Festival. What was back in May?
Yeah.
Something like that. I think it was early May. And we just so happened to get paired together to MC this event. And we started talking, and you told me you're a lawyer who deals with contracts and people who are in news and people who are in TV and kind of the entertainment world. And so here we are. We're going to just pick your brain a little bit about how you got started and then how we can help some of these news situations that we get ourselves into.
Yeah, I'm originally from Poland. I was born in Poland, born and raised. I went to school in Poland. I went to law school in Poland. And then when I came here in 2006, I believe, I unfortunately had to do the law school all over again. So basically, I have two law schools under my belt. Right now, it's mainly civil litigation. We do deal with contract.
Okay.
But it's mainly lawsuits over contracts, over also personal injury, real estate employment stuff, a lot of employment issues.
Well, we definitely have some employment issues happening in the news industry. That is something that we are definitely seeing, whether it's people wanting to break contract or people getting sued because they are trying to leave their contract early. We all know that we sign a contract. We have to live up to those contracts and the expectations of it. But sometimes we have to leave. Sometimes, things happen and we have to break contracts.
You mentioned breaking contracts. It's not always breaking contracts, right? Because contracts are, it's a piece of paper that people sign. When you try to get out of the contract, it's not always breaking the contract. Maybe the other side broke a contract first, which also might give you a right to break the contract. But to answer a question, what are the things you should be looking for when you sign a contract?
Smart contracts.
First things first,
protect your own interest. Before you sign a contract, you need to think about what you want to get out of it. Contracts, it's not a situation that is one-sided. Party signs a contract and signs over their life. It has to be of mutual benefit. They want to hire you. They want to make sure that you're going to show up to work and do the work. You want to get something out of it too, right? You want to mainly get the money. I guess the bottom line is that the parties need to first think about what they want to get out of the relationship, then simply put it down on paper.
You brought up a great point in the beginning. You said contracts are supposed to be upheld by both parties. And I think we forget that in news because we feel like we're going up against a big giant. It's us little guys against the big corporation.
No, I can see that. But what I said in the beginning, right? Both parties sign a contract. And one of them is breaching the contract. There's actually a so-called material breach of a contract. And if that occurs, then that gives another party the right to get out of the contract. When you are not getting the benefit of your bargain with your employer because they simply broke the contract on their part, that's one of the ways to get out of your own contract.
It's difficult to speak in abstracts, so let's move to real examples, as told to us. Exhibit A, request denied, option ignored. A Las Vegas Dayside weekend reporter was told to move to overnights. She documented a medical condition that prohibited the schedule. The doctor's note attached. A colleague volunteered to take the overnight slot. Management declined the swap and the accommodation, then terminated the reporter. In our contracts, we generally do have that we have to be flexible to work night shift, day shift, overnight shift, whatever that may be. And they ended up firing her despite her having multiple doctor's receipts and doctor's notes saying she can't do this. This is not something that is feasible for her to do.
Like this is kind of touches upon kind of like statutory protections of workers, because one thing is a contract. This is kind of like a legal framework of your relationship with the employer, but also you have many statutes and laws that are enforceable regardless of what you sign, whether it's Congress, the legislature of Nevada, or whatever state we're in. There are laws that protect workers, give you additional protections besides of what you see in a contract. So in this situation, for instance, you have a person with a medical condition that is documented, that is, let's call it disability, certain medical condition that prevents you to perhaps perform some part of your duties. At this point, if the employer is aware of this, they need to engage with you in the so-called interactive process to see if they can provide you with reasonable accommodation of your medical condition. If they can do it because of the resources, because of the type of work that you do, then they have to do it, but it has to be reasonable. You bring in a doctor's note saying, hey, I have a medical condition, I can't work in the morning, but I can work in the afternoon for whatever reason. I'm just making stuff, right? And if that's reasonable, if this is a reasonable accommodation that can be provided by the employer, then probably they have to do it. They cannot just fire you. They're saying, no, I just want you in the morning. No, it doesn't work this way.
She did get fired, and I do know that she did pursue legal action. In her case, it wasn't that she didn't have a case. It was just more that it was the time, it was the money, it was everything that gets involved in these kind of situations.
It's understandable, right? Of course, any legal dispute involves a certain amount of time, stress, and money too. You need to find a lawyer and perhaps sometimes pay a lawyer, right? So that adds additional level of difficulty here. But, those are things that we deal with on an everyday basis. We see it all the time. It does require quite a bit of effort on the part of the employee to be able to actually stand up and do enforce those laws that are written, whether in a contract or in the statute.
It's a tough industry, though, because I mean, we can go step by step by every firing that I know. Everyone has been different, but some of them have almost felt retaliatory. And I do know that, we can sue for that. To prove that is just a whole other level.
There are ways to prove it. There are different laws in different states. For instance, in Nevada, when you feel that something is wrong, try to document it as much as you can. Like, for instance, you have a medical condition, right? You're requesting this accommodation. Make sure that you send this request through email. There is some kind of a paper trail. Sometimes a person is requesting the accommodation saying, hey, I have a disability. I need to ask you to kind of accommodate it. Send this request writing. Because then if they do something to you after this, if they, take some kind of adverse action against you, then that's retaliation. And that's going to be very easy for you later to prove that, hey, just after I sent the request, they fired me. Then the burden is on the employer to kind of prove that the reason for the firing was not retaliatory, that it was something else. For instance, in Nevada, too, you can actually record in-person conversations with your employer. Like, for instance, you're called into the room because, I don't know, they want to discipline you, they want to discuss something with you. This is not a legal advice because each situation is different, but in many circumstances, you are actually able to record your employer, what they said, without them knowing that you're recording. But in Nevada, you have to be a part to this conversation, actually. You cannot record something over the phone without the permission. But let's say the way we sit here, right? I could have my phone here recording our conversation here without you even knowing about it. The main thing is just document. If you feel that something is wrong, just make sure that whatever you communicate with the employer, there's some kind of a paper trail or somehow it's recorded.
Exhibit B. Silence signed.
I ended up leaving radio, not because I wanted to, but it was more because I was kind of pushed out.
After 12 years on air, a San Francisco radio host was told the gears had shifted.
I can't talk too much about it because I had to sign an NDA.
No misconduct, no explanation. Just paperwork and a non-disclosure agreement.
It's real funny when you have to sign NDAs when there's nothing to hide. I'm just gonna leave it at that.
An NDA can protect trade secrets or conceal a story.
I just felt like a bad divorce, and I wasn't ready to get a divorce. I love that.
In this case, it did both, ending a career and muting the person behind it.
The only thing I have to my name is Shades by Shan, and I'm gonna put my heart, blood, sweat, and tears into this shit because I'm gonna blow this shit up because it has my name on it.
What followed wasn't revenge. It was a rebuild.
What's up, guys? It's Shan here at the JCPenney Shades by Shan grand opening.
From her mother's garage to a multi-million-dollar brand, Shan Berries turned silence into fuel. When we are being fired or we are getting let go, some of us have to sign NDAs. Jacob breaks down when an NDA crosses the line.
This is kind of a tricky situation.
From protection to power.
NDA is just like any other contract. In every contract, you have to obtain the so-called bargain for exchange. There has to be exchange of something. So if you promise not to reveal certain information in the NDA agreement, you probably have to receive something in exchange. It's very common to sign NDAs in the beginning of your employment. The idea is that, hey, you're going to sign the NDA, you're agreeing not to reveal our information, but in exchange, you're getting hired. You're going to get paid, right? But if you're getting fired and they simply make you sign an NDA and not give you anything in exchange, that by itself might indicate that this NDA is invalid because they need to give you something. At least, I don't know, $1, $10, $100, whatever, or some kind of a promise. They cannot just require you, hey, you're fired, you're not getting anything, you're not working for us, here, sign the NDA on top of it. You can say no, easy.
Is there a way that we can say no, and even if they are exchanging something and they want to get this money?
Yeah.
Do we have the right to do that?
Yeah, you do have the right to do it. NDAs usually cover some kind of a confidential information that the employer is disclosing to you. Even without an NDA, some information of the employer might be protected still. Like, for instance, if you get to know the employer's trade secrets, right? And you know it's a trade secret, you know it's not public. It's something that, the employer protects. Even without the NDA, you might be prevented from disclosing that information. To answer your question, you can refuse anything. You can refuse to enter into any contract.
That is so countercultural to us in the news industry. So like when we hear that, we have contract shock, right? Like every time, because it's just, we know what the basics are. We know what we're going to get into. And then we also understand that when we take this job, we're going to be asked to do a lot more. When we're starting out in this industry specifically, I think we all just want to say yes. And we are hoping that our employers have our best interest at mind. And when we start working, that may not always be the case.
No. Your employer does not have your best interest in mind. Your employer just wants you to do the work, okay? They're not out there to look after you. They're not, some employers are better, some are worse, but at the end of the day, they just want you to do the job. And they probably want to pay you as little as possible and as little as they can get away with to keep you employed. But it's not like your employer is out there to look after your interests. No, you have to do it yourself.
The other thing that we're seeing also is some of us are having to sign away our social media accounts. Now we are signed on with our own following, with our own large numbers, and companies are hiring us because they like the numbers we're bringing and the eyes we're bringing. When we get there, we have to sign over all of our social media, which means once we leave that company, our social media stays with them and we lose it.
That is very interesting, actually. I didn't know that, to be honest. But that creates a whole lot of other issues.
I'm sure it does.
Because, yes, I understand that it might be a job requirement for the employer to sign over your social media. But at the same time, those social media platforms like Instagram or Facebook, they have their own terms and conditions that, by the way, prevents you from signing over your social media account without their authorization. So technically speaking, depending on the platform, that by itself might be in violation of the terms and conditions of Instagram or Facebook or whatever it is. And that possibly might be reversible. If they're asking you to sign something over, you should get something in exchange for it.
I mean, in their eyes, you're getting a position on TV. Right.
I can see that.
But again, it's like a mutual benefit because a lot of us are being signed on because of the following we have, because of kind of the eyeballs that we can bring to the station.
I can see that. I can see why they would want to do it, why some people might be inclined to even sign over this kind of stuff. But each and every of these little areas, creates a different legal issue here.
Sure.
It creates legal issues when it comes to employment, when it comes to contract law, when it comes to laws governing those social media platforms, because also, like, for instance, I don't know, Instagram, right? We know that they're incorporated, I believe, in California, right? So their laws apply to the social media accounts, right? Whatever you do with the account, probably you should check with them too. First, if whatever the employer is asking you to do would not violate their terms and conditions, because the situation that you want to avoid too is that you agree to something, to do something for the employer, and then, on the other hand, you're exposing yourself to liability from someone else. For instance, a social media platform.
Lots of layers there.
Absolutely.
Lots of layers there.
That's what law is about. Yeah. a lot of issues.
A lot of issues
everywhere.
This is why you're here, because we have a lot of these issues in our industry. Exhibit C, trimmed, then traded.
There was a mass exodus from my station.
That's Toi Thornton, who left the business after more than a decade in local news.
I was a weekend morning anchor. The two main morning anchors left shortly after I left. A couple of reporters left. Meteorologists left right before me. So it was a mass exodus.
Today, he teaches communications at his alma mater, helping students navigate an industry many of us barely recognize.
I'm sure that everybody has their own story and reasoning as to why. Some people went to other stations. Some people got out.
The exits he's describing weren't isolated. We have a mass exodus of people. We have people who are burnt out, which goes back to the amount of hours that we are working. The fact that stations are trimming the people in these stations. 6 positions cut to 3. We were already doing the job of so many people, Toi. Like, I remember I was able to do the director's board at some point, the audio. But you're being told that, hey, we're going to keep pulling resources from you. I'm already doing the job of 4 or 5 people. How many more jobs can I do? How much more can I give?
In those mass layoffs, like, for instance, companies are firing, thousands of people. There's certain notice requirements, sometimes severance packages that have to be provided.
Our station at Lafayette, there are not very many people that were there with us who are still on TV. In fact, I can't think of one.
Others watch their stations sold off. We have people leaving, breaking contracts, but we have stations now walking in and just closing down, shutting down, or firing people. How can people get some kind of help for that or relief for that?
It all depends what kind of agreement you have with your employer. For instance, if you sign a term contract saying, hey, you cannot terminate me for 2 years. In exchange for this, I'm going to receive this amount of salary. I'm going to sign non-compete or whatever it is. And then if they want to fire you because before that term expires, that's absolutely a breach of the agreement, and you have the right to go and pursue a legal action for that. When it comes to smaller companies, there's really nothing, unless you have a contract, that can prevent them from firing you simply because that's the business requirement. But they cannot fire you, on the other hand, for illegal reasons, right? They cannot just fire you because the station decided not to employ women anymore. That would be absolutely discriminatory, and that would be against those statutory protections that are out there, regardless of the terms of your contract. Right now, I understand that there's a lot of pressure on news agencies to trim expenses, people and stuff because of, internet or whatever, however the industry is changing, right? And on one hand, I can understand why they want to do it, but on the other hand, they have to fulfill their own legal requirements in order to be able to do it. So if you have a contract, let's say for 2 years, and they fire you after a month because their business model has changed, then probably you might have a claim.
here's the other thing, right? Like contracts are not written for us. Contracts are written for the employer, correct?
It depends. Again, I'm a lawyer here, right? Because the idea is that contracts should be written for both parties. The contract should be of mutual benefit to both, right? Because again, that's why we have contracts, right? To assure that one person gives me something and I give something to the other person. But the reality is that, yes, those contracts are usually contracts, there's so-called contracts of adhesion. Basically, they give you a form to sign and you sign it, right? There's no negotiations over this. You can always ask for more. You can always ask to change something. You don't have to sign a paper just because they ask you to sign it. There's no requirement. The worst that can happen is that you don't get a job. If this job is as important for you as to kind of force you to sign the contract that they're offering you, then yes, probably you have to sign it. But it still doesn't mean that this contract is enforceable in all of its aspects, right? It might not be enforceable at all. But what I'm saying is that no, the contract is not meant, any kind of contract is not meant to protect only one party to the contract. The idea Ideally, yes. Yeah. Ideally, it should protect both parties.
We're seeing a lot of companies right now merging. We're seeing a lot of companies buying other companies out. We do see layoffs. We see a lot of these things. What should people be on the lookout for?
If the company that you work for, you signed a contract with, is bought by someone else, still they have to uphold that contract, unless the contract says something else. In case of a buyout, in case of merger, acquisition, whatever it is, this contract is invalid. You rarely see it, usually in a position of like CEOs and higher upper management, those kind of clauses. But if you sign a contract with a company and the company is being bought by someone else, they still need to honor this agreement for the most part. Questions like this, I would need to see, hey, what does the contract say? The contract says that I signed a term for 2 years with this particular company. And in case of a buyout, merger, whatever, either this contract expires, is canceled, or is being honored.
Maybe the question should be then, what should we be looking for in these contracts? Because that is what we are seeing right now. What we know in the industry is that every time we are bought out by another company, there are always layoffs on the other end of that, and they will say, no, everybody's got a job. And then 2 months later, we're trimming the fat. When we are signing these contracts, what are the top things we should be looking for?
What you care about the most, right? So how much money you're making.
Mm-hmm.
So that's something that should be delineated with increases. If you work for, you sign a contract for 2 years, probably there should be some kind of a provision saying that the first 6 months I'm getting X amount of money, and that's going to increase by, X amount of money later. The delineation of your job duties. This is very important, right? This is something that you said before, that the employer comes in, they change your job duties out of nowhere. So if you can describe those duties, at least you have some kind of a security that they're not going to assign you from doing a news anchor job to a position of a porter or something.
They will.
Yeah.
They will.
But exactly. So even if it's pretty vague, right, you can say, hey, I'm getting hired as a news anchor. My duties involve, reporting, writing, and, editing. So we talked about money. We talked about job duties. And then the third big thing is, the term. Is that an at-will employment, meaning that you can be fired at any time? Or do you want some kind of a job security, at least for a certain amount of time? If you can agree on those three main things, those are the three main things that are probably the most important to you. The fourth one, in your situation, right, in a situation of news anchors, is this non-compete. This is pretty important because it's very common. It's not common in many industries or in many contracts, but it is common. And if you say that you guys all are signing it, look at what this non-compete says and what's its scope. Non-compete has to be reasonable when it comes to scope, time, and geographic kind of scope as well. A non-compete, first of all, has to protect a legitimate employer's interest. So they have to have a legitimate interest in signing a non-compete with you. It cannot be just a whim saying, hey, I feel like I don't want her to work for anyone because I'm jealous, right? No, it has to be some kind of a legitimate employer's interest. And then on the other hand, it has to be reasonable to the point where it cannot basically prevent you from making a living. If you're signing a non-compete saying, hey, I'm a news anchor, and for 5 years or 10 years after working for you, I cannot work as any other news anchor in the world, anywhere, or anywhere in the US, then probably is invalid, because it would prevent you from making a living within this particular field of profession.
On that note, when ideally should we be receiving our contract?
before you start any kind of employment, ideally. Before you start doing any kind of work, the contract should be entered just to make sure that everyone is clear and everyone is on the same page. But with that being said, I've seen over and over, again, I do it myself too sometimes. We hire someone and then for whatever reason we want to change the conditions of the relationship, so we sign the contract. Or we negotiate the terms of the contract to change it to fit the relationship, basically, but not to fit only one person. Because if the contract is written only to protect one person, it usually ends bad.
This was the first state that I've lived in where when I got my contract, I didn't even see the full contract until I got here to Vegas, and I was already working.
So if that's the case, then we have another issue here.
But that seems to be more and more common because I see that in the threads on our MMJane group. I'm seeing that people are kind of saying, when should I be asking for my contract? Because some companies are telling us, oh, you'll get it when you come here. We'll show it to you there. We have certain terms we negotiate in email, and then we don't see the actual contract until we get to the state.
Until you see the contract and agree to it, there is no contract. Each contract requires the so-called meeting of minds. Both parties need to be aware of the terms of the contract in order for them to agree to it. So if you don't see a contract, there is really no contract. But I understand there are some kind of many different situations, exactly what you just mentioned, that, we're negotiating something through emails, right? And then, I come to work, I start working, and then they give me a contract to sign. I can see how something like this could be valid because, as I said, the contract doesn't have to be in writing.
Right.
And a contract, oral contracts are valid. Even if you put just pieces of it in writing, general contract that is in oral, that was not written down, it might still be enforceable.
Okay, well, I'm going to put you through the ringer here today because we went through a lot in this Las Vegas station. A lot of us in that station who are no longer there, some who were fired, some who left on their own accord, some who quit, all of the above. Some of us had a lot of verbal contracts with our first management. And then our first management got fired. And then we had new management brought in. And that management did not honor a lot of these verbal contracts we had. The new people that came in had a new vision for the station. And so a lot of us were kind of salty, but we were still held to our contract. The things that we were told were not coming to fruition.
And that's an issue. That's more of an issue of evidence and to prove what you agreed to, even orally. It's more of a documentary issue, basically. It doesn't mean that your contract is invalid only because new management comes in. It doesn't work this way. If the first management agreed to something, even if it's not written down, it might still be enforceable. It's just a matter of proving it. If something is oral, it's harder to prove, but it doesn't mean it's not enforceable. Oral contracts are enforceable. There are certain, rules and regulations as to how they are being enforced and how much time you have to enforce those, as opposed to written agreements, but they are still valid, just as valid as written agreements.
How do we approach that with management? Because again, in our case, we had just a lot of very unhappy people. And I remember sitting in our news director's office and she said, the last management offered a lot, promised a lot, but we are not here to deliver those promises.
The rule of thumb would be what I said in the beginning, document. For instance, if you have an oral contract with the management, right? The management says, hey, if you work, 10 hours a day, I'm going to give you some extra money, right? And after something like this is agreed upon, send an email saying, hey, just to memorialize what we discussed today, you agreed to offer me more money if I work 8 hours or more a day, right? And then already you have document saying something, hey, on this and this day we had a discussion. Here's the proof of that discussion. They didn't send me an email saying, no, this is not true. They didn't object to it or anything like this. They simply agreed and we moved on. And that by itself indicates that the contract was actually entered into. And you already have some evidence to prove it.
Okay. Well, it all goes back to documentation.
Yeah. Lawyers, they love to do this all the time, right? When lawyers get on the phone, usually because lawyers like to, I don't want to say misrepresent the truth, but they like to twist things, right? So when I have a conversation with a lawyer, especially a lawyer from the opposing side, if we agree on something over the phone, I send them an email afterwards saying, hey, just to memorialize our discussion today, this is what we agreed to.
The Hive's just waking up. Join us for monthly lives and weekly minis on Patreon. Your support turns words into healing